we were discussing whether we were going to invite Mr. P. Dittabus in to testify. I have since reconsidered and will withdraw that request. So we can continue now and allow the members to ask any further questions. We move on. Representative Torres.
Mr. Chair, just to let the members know that I found out later during research time that the difference of the two agreement option to lease, I'm satisfied with the result. Thank you.
Mr. Chairman, for the committee's sake and for just to clarify, can you please tell us what is the difference between the March 27 option to lease and the August 3rd option to lease? First, are both valid or one is valid over the other?
Both valid. Both agreement or option to lease are valid. One is for the power plant facility, and the other one, no, the March 27, 2012 is for
Ship.
For the power plant, and the August 3rd option to lease is for shipyard. So there's totally two different options to lease. Now, what's in there that changes both or different? I think that's the legal, what do you call it? Legal groups to clarify that and correct.
Thank you for that clarification, Representative Torres. Any other member? Representative Deb.
Further clarification to Representative Torres's comment on the both option lease being legal. The other difference is within the first option to lease contains Exhibit A, and in the first March 27 option to lease also has Exhibit B. Oh, I'm sorry, this latest one has Exhibit B. This is the August 3rd, and the Exhibit B contains statement of disclosure, and it reads, part of the option land is not currently in the legal possession of DPL, and I would assume that it belongs to somebody. Following execution of this option to lease agreement, DPL shall promptly proceed with all actions and efforts necessary for DPL to obtain an unencumbered legal interest in and possession of option land. That's the big difference, and I think this is glaring for DPL or for that matter, NMD in concern. Thank you, Mr. Chairman.
Thank you, Rep. Would DPL like to kind of clarify the statement or the Exhibit B, that statement which talks about part of the option land is not currently in the legal possession of DPL, and that DPL will promptly proceed with actions and efforts necessary to obtain an unencumbered legal interest and in possession of the option land. Can you clarify what that means? And before I do that, also please clarify, because I think I got DPL on record earlier stating that I asked a specific question, was the property in question, did DPL hold title to it? And the answer was yes. And now we find that not only is part of it not, the title to part of this land is not in DPL's possession, I think that's what the statement, Exhibit B, Statement of Disclosure states. Maybe you can clarify that for us. Thank you.
If I may, it is my understanding, and I checked with our zoning department and our planning department about this land on the morning of the 3rd, I remember, and it is all public land, is what I was told, so we hold title to it all. I mean, whether or not there's a lease on a portion of land that's actually outside of the boundary that I saw, perhaps, but within the boundary that I saw, it was my understanding that there was no current lease other than perhaps a designation for public works that just needs to be negotiated around or negotiated with public works on what to do with their temporary interest in the land. But as far as title is concerned, it's my understanding that it's all public land.
Just to clarify, and I think Mr. Salas can further clarify, there are public lands in which the Department of Public Works does not hold title to. In their enabling legislation, and I think even I know in the law, that they do, in some cases, transfer title to other agencies. Those properties are public land, but title and disposition of that land is no longer controlled by DPL. So, and that's why I wanted to get that clarification.
If I may, a designation, and I honestly I didn't look into the Department of Public Works designation that we have here, but it's typical for our designations for use of public land with other agencies is there's a clause in there almost always that DPL can unilaterally cancel the designation and retain full rights back. But title always stays with public lands. Designation is just designation of use. It's like we're allowing you to use the land, and whenever we want and whenever we need to, we can take the land back. But title always is with DPL.
Let me give you an example, and I'm not gonna, debate this. It's just to get clarification because my understanding and your statements do not agree. DPL has transferred title and I believe ownership to the Commonwealth Ports Authority. They have in the past. Those properties and the lease and the revenues generated from those leases go to Commonwealth Ports Authority. They do not go to DPL any longer after those transfers were done. And I know that there were cases where there were disagreements as far as who had rights to those revenues, but because the property, I'll give you a good example, is Puerto Rico, the ports area. Those are now being subleased to leaseors. Correct me if I'm wrong, but I believe the revenues from those leases are going to the Ports Authority. Is that fair? Is it correct?
That is correct.
So that's why I'm not unclear with what you're saying, that they still hold title to. If they did, I'm sure they would assert their rights to be able to have those rental revenue go to them. But I don't think that's the case.
If I may, I thought the topic of discussion here was about DPW and the land that's inside the option area, not the Ports Authority or some other contract that we have with someone else. As far as DPW is concerned, I believe it's a designation of use, which could be unilaterally terminated by DPL at any time, with or without cause.
Thank you. And I was merely stating that there are cases where title is granted. And I don't know if this was the case, and that's what I wanted to get clarification, was whether it was a transfer of title or just a designation. And you've responded that this is a designation.
To my knowledge, yes.
Thank you. Thank you. Any further questions of Mr. Salas?
Sure.
Representative De La Cruz.
I don't have a question for Mr. Salas, but on the issue of Exhibit B under the option to lease document, again, the understanding here is that most, if not all, of these documents prepared and signed off on were coming from the Attorney General's office. I understand that we have subpoenaed Mr. Burnbrick, Assistant AG, on Article 9 as well, to be present here. And I think at that time, this question with regards to a partial of the option to lease property would be better addressed to Mr. Burnbrick. Although I also feel that if this committee needs further clarification, that we may ask DPL to provide the property in question.
To provide the property in question, I think we have the map already.
We do have the map, Mr. Chair, but this committee is still unsure as to exactly what is not under the ownership of Department of Public Lands.
Thank you. And then further, one last point of concern, Mr. Salas and Mike, and that is that exhibit the option to lease agreement signed on August 3rd does not have any reference to specific lot numbers, or it just says exhibit B, is it? I'm sorry, exhibit A, which is the map that is attached. And the concern here is, without any reference to lot numbers, it is ambiguous. We don't, there's no, I mean, exhibit A can change. There is a potential for land to grow or boundaries to change, and I wanted to caution DPO about that. The March 27 option to lease was very clear. It referenced the lot numbers. It referenced the size of those lot numbers. The August 3rd did not, and I'm very concerned that, and I think we have a right to be concerned, because without those designations, you know, I can take Exhibit A and change it tonight, and nobody will ever know if this Exhibit A is different from the earlier Exhibit A. So I'm just saying, raising a concern that the potential is there, and Mike, of all people, you would know that you, for any legal agreements, you want to be as clear and as specific as possible. Can you respond?
Sure. Just to alleviate your concerns, I'm sure multiple parties have copies of the agreement, including Exhibit A, that was signed. So if someone were to go change Exhibit A, they could only change their own copy or something. And if there was ever a discrepancy, then the issue would be taken up then. But there's not just one option contract with one Exhibit A. There's multiple copies of it out there. So,
thank you for your clarification. If there are no further questions, we can. Representative Sablan.
Thank you. It's Mike and Secretary. I know that earlier you mentioned that a copy of the option to lease was provided or was available. I don't know how it got to DPL, but you said it was available sometime in the morning?
yes.
approximately, do you recall? If not, then...
I don't know, probably 9 a.m.
Okay, and it was presented to the office in the morning, and he also said, or the secretary said that it was signed off in the afternoon. Again, let me ask this, was there any specific instructions or request that the documents be signed in the afternoon?
No, it was just when we had our second meeting about the options contract, and everything looked fine from as far as legal form is concerned. So, and the acting secretary agreed with it.
There was not.
There wasn't
any,
a demand.
There wasn't any indication of urgency from anybody. Nothing.
No, not that I remember.
Do DPL, as a practice, signed off documents presented to the department within hours?
We were very busy at DPL, and it depends. I mean, if we're done and there's no further, if it's not necessary to have any further meetings or discussions about it, if everything's clear, then why not just move forward?
And you know, I hope that's the standard practice of the department in regards to other leases coming from the department, because that's not what we hear from the general public out there when in regards to
leases are a different matter. This is just an option to lease.
It's
an option. This document here is merely an option to lease. Leases go through a much more formal process.
Well, I'm just making a statement that I hope that urgency is afforded other customers of DPL. Thank you.
Are we ready?
Ready.
One last.
One very quick one.
Thank you.
Chairman. Mr. Salas or Mike, any one of you can answer this. Are you aware of a lease agreement that has already been prepared for this particular option to lease agreement?
I'm not aware of a lease agreement. I mean, I could only speculate that there may have been one. I mean, if Oscar Babauta had been working on an option earlier, then perhaps there would have been discussions about a lease agreement, but I'd only be speculating.
Okay, and my last question real quick, based on Rep. Sablan's line of questioning, this document, the option to lease that was signed on the 3rd, where did this lease come from and how was it delivered to DPL?
Okay, well, it was given to me by Gil Burnbridge, and I believe, this is just from memory, I believe it was through email. That's usually the quickest way, so I believe he emailed it to me, and I printed it out and we had a meeting about the document, but it came to me from the Attorney General's office.
Thank you, Mike. Thank you, Mr. Salas.
Thank you. We are kind of behind schedule. We still have several individuals, and we do have a 1 o'clock with CUC. So with that, if there's no further questions, I'd like to dismiss the witness. And thank you, Mr. Salas, Mr. Secretary, and Mr. Mike for appearing and for cooperating. I will dismiss you, and should the committee want to ask you any further questions, we may give you reasonable notice to come back and appear before this committee. So kindly ask that you leave your contact numbers with our Sergeant at Arms here, Mr. Joe Sablan. And with that, thank you very much. Have a nice day.